Okay, everybody, if you can take your seats, we are ready for our last session, legal considerations. We have Lauren Olson joining us, and she is with Lou Pearson Olson, and her office is in Plano, and she is a fellow Ursuline grad. So if y'all can make your way to your seats and stick around for this legal considerations.
I think I'm good on this, right?
I think they can switch it up.
All right, can everybody hear me? Oh, I just got it snapped off. I'm gonna put it there. Okay, how about that? Okay, good deal. Good afternoon, everybody. First of all, like Anna said, my name is Lauren Olson. I'm a partner at the law firm of Lou Pearson Olson, and we're just in Plano, so not too far from here. But I want to start off by thanking Anna and Michael and everybody else at the Catholic Foundation for today's wonderful seminar, because when it comes to ensuring that your wishes are followed, whether it's medically or legally, information and education is key. And it is conversations like this, especially through the lens of Catholic moral teaching, that are so critical for all of us. And so, hope everybody learned something today, and will share that, most importantly, right? Share what you learned with a friend and family member so that everybody else can benefit from all of this information. So I think, like Michael said in the last one, is that not everybody, wakes up in the morning and yawns and thinks about their wills and their powers of attorney, but I actually do, believe it or not. That's exactly what I do after I say a few Hail Marys. But yes, I am an elder law attorney. And so you may be thinking, well, what is an elder law attorney, right? You may think, oh, well, I have a will in place, and I met with an estate planning attorney, and so I'm good. That's it. That's really all I need. Well, elder law is a little bit different. Okay? Elder law focuses, instead of just on one area of the law, it focuses on a type of client. Okay? And in particular, that is older adults and their family members who may be dealing with issues of incapacity, and in general, people thinking about long-term care and end-of-life decisions. So that's the client, right, the clientele, and then it encompasses all different areas of the law that fall within that umbrella. Okay, so that includes estate planning, absolutely, right? Estate planning that, again, may be a little bit more geared towards incapacity planning as well as long-term care planning. Also within the branch of elder law is public benefits planning. Okay, so that includes Medicaid benefits as well as veterans benefits that we want to keep in mind when we are designing your estate plan. Okay, so we talked about estate planning, we've got public benefits planning in there, and then we're also in the courts. Okay, so we do probate proceedings as well as guardianship proceedings, and in our office we do both the contested ones, and believe it or not, people tend to fight sometimes about these things. I know, look at that. So we also do the contested work as well. So that's kind of what elder law is about. And again, this is not just about, and as you guys have already heard a lot today, this is not just a one-stop shop, create a document, check that, off your to-do list and move on. What we want to do is we want to approach all of this with a, kind of a roadmap to the aging process and talking about creating a comprehensive long-term care plan for you. Okay, so when we're thinking about that, we want to look at some goals. We want to approach that with some goals in mind, okay? So first of all, we want to maximize our quality of life. And believe it or not, we can do that by making sure that your wishes are followed and ensured in that process. So maximizing quality of life, making your wishes known, both during your lifetime as well as upon your passing. And then really important too, and growing even more important these days, is to protect you from exploitation. I could sit here and talk for hours about the exploitation and abuse that is currently going on and is rapidly on the rise. So documents, it's important to have documents in place your wishes known and communicated, and guardrails to try to prevent that exploitation from happening to you and your loved ones. And then, of course, as part of that long-term care plan is also to make sure that you have enough assets in place to pay for long-term care. So, not just documents, right? There's a lot more involved in this process. So, speaking of roadmaps, here's our little roadmap for today. We're going to kind of break this down into 3 sections. We're talking about how to ensure that your wishes are followed first during your lifetime. Right? And so we're going to do that. We can do that with these key documents that we're going to break down here in a second. We're going to go through these documents that affect you during your lifetime. And then step 2, we're going to talk about documents that ensure that your wishes are followed upon your passing. And then hopefully if we get enough time, we are also going to talk about ensuring that your wishes and desires are followed with respect to long-term care and paying for long-term care. So this now is not, like I said here, not the time for do-it-yourself planning, okay? The most important thing that you can do to make sure that your wishes are followed is to have sufficient and updated documents in place, okay? And you really, really need to do that with an attorney. And I'm not just saying that because I'm an attorney, right? You can go to any attorney, but it is really key. I mean, this is a crucial time that you have to have professional help involved. And it's really important to do that, okay? So when you go meet with an attorney, be prepared for that, right? That's an important meeting, and so you want to take the time to prepare. And I like to talk to people about this because sometimes they don't know the questions to ask, and they don't know what to bring to that meeting, okay? So what you want to be thinking about, again, is not just the documents themselves, right? So the attorney needs to know who are your people. Of course, you're going to be prepared with that. But also make sure to have your financial information ready, because we want to be talking about your assets, where your assets are, how they're titled, as we just heard a minute ago, beneficiary designations. Are they on those assets? Are they not there? And then also, it's important to have information about health insurance, right? So maybe you're on Medicare. Do you also have a Medicare supplement? Or is it an Advantage plan? And then, of course, if you are a veteran, having military, your DD-214 or any discharge paperwork can also be beneficial when you're meeting with an elder law attorney to talk about paying for long-term care and some benefits that you may or may not be eligible for. So, and we talked about preparing for the attorney meeting. Now, kind of phase 1 that we're going to dive into is these are the key documents here that you have to have in place to make sure that your wishes are followed during your lifetime, okay? So every single person in this room, really everybody, whether you are 27 or 77, must have these documents. Now, a lot of times people come to me and they say, well, Lauren, I don't need any of that. I just want a will, right? Don't worry about that. I just need a will. Well, yes, the will is certainly important, but even more important than that are your powers of attorney and the documents that are going to take care of you during your lifetime. Because if you don't have these documents in place, then your family and you become incapacitated and you can't make these decisions for yourself anymore, then your family members are going to end up in court, okay? And that is an expensive and emotionally painful process, which we're going to talk about. So, the most important document, even more important than the will, is this statutory durable power of attorney, okay? So let's talk a little bit about this. This is the document where you are naming someone who you trust to step into your shoes to make financial and legal decisions for you, okay? So we're talking about who. In the document itself, we're going to talk about first who you want to name as your agent, okay? So just because you are married, like husband and wife, for example, just because you are married doesn't mean that you have the legal authority to act or make financial decisions on behalf of each other. For example, your home. Oftentimes, your home, your homestead, is titled in both husband and wife's name. okay? So if wife became incapacitated and husband needed to get, a home equity loan or sell the house or do something without a durable power of attorney in place, husband cannot necessarily make those decisions. We have to have that in writing, okay? Now, if you are titled jointly on a bank account as co-owners, well, then maybe the co-owners can make decisions for each other on that account. But again, this is why it's key. Just because you may think that your family members can make decisions for you, that is not always the case. So we have to have a primary agent. Maybe that's going to be your spouse or one of your children. And you also have to have alternates, okay? So oftentimes people will ask me, well, I want to name my husband as my agent, my primary agent, which is fine. And then I say, that's great, and what about your alternates? Well, we've got 3 kids, so let's name all 3, right, as co-agents, as the alternate co-agents. And I say, well, that is a very bad idea. And I say it more gently than that. But oftentimes people want to do that because they want to treat their children fairly, right? And that's maybe the case with respect to the division of your estate. But when we're talking about decision making and appointing somebody to be your agent, it's really important to have one person make those decisions, okay? In a durable power of attorney, I will say legally, you can have co-agents to act independently of one another. However, in my experience, as I mentioned a minute ago, we do a lot of litigation in our office as well, and I would say about 75% of the litigation, the guardianship, the contested guardianships, the contested, the will contests, that's a result of co-agents, co-executors, or co-trustees under a trust. And that may just, sometimes that's just because when people pass, family members, things change, right? And so that's just my experience, is that it can be beneficial to really name one person, if you can, to step in and sign that dotted line and make those decisions. Of course, you want your children to be in discussion with one another.
Sorry to interrupt.
No, you're right.
Is it you want one agent for legal and one agent for financial, or you recommend that you combine them both?
So these are all in one document. They're combined. So when we're talking about financial and legal, but that is going to be separate from medical, because medical power of attorney is going to be a separate document. So you could name, your son with respect to financial decision making, and then your daughter, who might be a physician or in the medical professional, that she could be the agent under the medical power of attorney. So we talked about our agents, and then we also want to focus too on when the document becomes effective. So I want you all to, if you have powers of attorney in place, when you go home later today, take out those documents and take a look at them. And there's going to be one section towards probably on the 2nd or 3rd page that talks about when the document becomes effective. So the options are either A, and it's typically bolded, either A, that you want that document to become effective immediately, or B, only upon your disability or your incapacity. Now that's what we call a springing power of attorney. Okay? That means it only springs into effect once you've been determined incapacitated or unable to make those decisions. That springing option, that second option there, does require a doctor to certify in writing, that Lauren Olson is totally incapacitated before her husband could make any decisions for her. So my philosophy is that you should trust the people that you're naming, and I really recommend that you make it effective immediately, because we often need these documents more in emergency situations, right? So we gotta have our agents to be ready to act right away and not have any roadblocks in place. A couple of years ago, talking about where the documents is signed, a couple of years ago there was a law that passed that said, if you want your agent to use this document to sell real property on your behalf, the document, the durable power of attorney, needs to be signed in an attorney's office or in the office of a title company. Okay, so that's another reason why kind of pulling documents offline is not necessarily in your best interest. Okay, and I don't really like that law, but that's the law, and we gotta go with it. Okay, because I have seen title companies that are enforcing that. So important where the document is actually signed, And then lastly here, I often get the question about capacity. You know, my mom, she was diagnosed with, Alzheimer's, and can she sign documents? Can we make changes to those documents? And the answer to that is, well, it depends, right, with respect to how far along she may be within that process. But just because somebody has a diagnosis, a cognitive, decline, that does not mean that they cannot sign documents anymore. Sometimes it's even the best time, right? Like you get a diagnosis and now it's time to get all of our affairs in order, make our, updates, make sure everything is exactly as it needs to be. To sign a durable power of attorney, it is contractual capacity, okay? And in a minute, I'm going to talk about the will, and that's what we call testamentary capacity. All right, so contractual capacity, and again, we don't want to get too much into the legalese of it, but essentially what that means is that you have to understand the nature of the transaction that you're entering into and the consequences of that. Right? You got to understand what power you're conveying to your agent and what that gives or allows the agent to do. So not necessarily that you can't sign documents just because you have a diagnosis. So then we want to talk about the powers, okay? So in the durable power of attorney, again, when you look at yours, and you're going to go home and take a look at yours, on the towards the beginning, it has a standard list of powers. This would mean give your agent the ability to handle your bank accounts for you, handle your IRAs, your 401ks, make a decision with regards to real property, right? Selling the house or something along those lines. Those are the standard statutory powers. In addition to that, we also now have what's called hot powers, okay? So this is an extra list within the document that provides, an example of a hot power would be it gives your agent the authority to change beneficiary designations for you. Yes, and I see a face like, ooh, that's a tough one. And that is exactly our reaction to that, is that hot powers are, there are advantages and disadvantages of that. And so this is a broad document, a document with broad powers. And so you got to think really carefully about some of those, the authority within that document. But beyond your standard list, then there's also expanded powers. So as an elder law attorney, when I'm meeting with clients, again, remember, we're not just here to check off the box on the documents. We want to think about our long-term care plan. So I want to incorporate in this document powers to be able to plan for long-term care. Should you need Medicaid or veterans benefits in the future, let's give your agent the authority to communicate with Health and Human Services, communicate with the VA, have expanded gifting powers. Okay? A power of attorney gives an agent the authority to make gifts of your assets, if you choose that, and typically up to a standard amount. Now we can expand that gifting power to be able to help your agent qualify you for public benefits in the future. That would include signing deeds to real property, setting up particular types of trusts on your behalf, including what's called a Miller Trust that I'll touch on for Medicaid purposes. So lots of powers, right? This document I could go on for days and days, but big and most very, very important document. Okay, so that's the durable power of attorney, which then we transition to the medical power of attorney. The medical power of attorney is, again, a document where you are naming someone who you trust to step into your shoes, but this time to make medical decisions for you. So that includes everything from talking to doctors, authorizing procedures, dealing with medications, and most importantly, making an end-of-life decision for you. Now, by operation of law, the medical power of attorney does not become effective or kind of spring into effect until you are unable to make your own decision, right? And that makes sense, though, because doctors are always going to turn to you to make your own decision for yourselves. And if the physician feels like he or she's not getting good feedback from you, then will they turn to your agent under the medical power of attorney. Now, this document, especially under the Texas form, only allows one person to serve as your agent. And again, you can have alternates in place after that, but not co-agents. again, medical professionals really need one person to be able to make those decisions for you. And I will say too, that talked a little bit, mentioned on the last slide, medical power of attorney does not give your agent the authority to choose where you should live, okay? So a lot of times people say, well, I'll sign this medical power of attorney, but I don't want my son to put me in a nursing home, okay? Well, you need to know the medical power of attorney does not give your son the authority to do that. The only person that has legal authority to do that is a guardian. And a guardian would be created in the probate court and appointed by a judge of a probate court, okay? A medical power of attorney does also not have the ability to exclude family members from you, right? So again, if children are fighting and trying to keep, their siblings away from mom and dad, medical power of attorney does not have the legal authority to do that. So this is where I want to touch on, Dr. Thompson was great earlier today, really delving into, Catholic moral teaching with respect to end-of-life issues. And medical decision-making, long-term care planning, all of this is very complex, right? And this medical power of attorney, when you look at it, and you're going to take it out and look at yours when you get home, your medical power of attorney seems simple, right? It's a 2-page, 2 or 3-page document, but there is so much in between there, right? That medical power of attorney does not say. So thankfully, we have the Bishop's End of Life Project that has stepped in to try to help fill in some of these gaps. And as Catholics, we believe strongly in the dignity of human life, right? And the importance of preserving that and advocating for that. Maybe your medical power of attorney, the agent in your medical power of attorney, isn't Catholic, right? There could be situations like that. And so the Bishop's Project here has created a Catholic medical power of attorney as well as a Catholic advance directive, okay? And I have specific language on a form in the back for all of you to take home with you. But generally, this project is they gathered a bunch of Catholic lawyers, Catholic doctors, and bioethicists to come together and to create specific language to be able to account for some of those Catholic medical and end-of-life decision-making. In general, you should know it kind of is just it's a list of directives, like general directives at the beginning of your medical power of attorney that says, I am Catholic, I want my agent to take that into account when making these decisions. Okay, so again, great language from the Bishop's Project here that I have for you in the back. And then here's the URL for it as well in your materials. So that's the medical power of attorney. And then there is also the directive to physicians. This one is commonly called your living will. You've all heard that term, right? In fact, you heard it earlier today, again with Dr. Thompson. Living will is different than the DNR, and she touched on that too. DNR is do not resuscitate. That is just about cardiac resuscitation, and that's something, a form that you would do with your doctor or medical professional, not with your attorney. But a directive to physicians, a living will, is a legal document that you should do with your attorney, and you should do it soon, right? Like she said, and that was a great point too, is to do it now. Do it in advance so that you're not in a situation when it's a critical or crisis moment, okay? So that's really key, and it generally it talks here about making a decision to discontinue life-sustaining treatment, right? Or to continue that life-sustaining treatment. You're not naming anybody in this document. You're just making your wishes known. Again, this document, according to Texas law, is rather simple, black and white, A or B, C or D, but there's a lot of gray when it comes to these types of decisions. So that's where the Bishop's End of Life Project also has provided some language for us. And the biggest difference between the statutory form as opposed to the Catholic directive has to do with the withdrawal of nutrition and hydration, okay? And so it's a little bit, the standard form is broader about that, and the Catholic form has some more specific directives about when to withdraw that as opposed to not. Okay, so definitely want to look at and incorporate that language when we can. HIPAA, you guys all know what a HIPAA is. I'm going to kind of breeze through this one. This one's just about sharing medical information with your family members or anybody else that you would want to have medical information about you. Now, the HIPAA has no decision-making authority. So oftentimes when somebody may not want, like a sibling, to necessarily have decision-making over them, but they could still find out information about how they're doing. So this would be a good place to add somebody else onto that document. Okay, so now this next one is a declaration of guardian. You all may not have a declaration of guardian. It's a little bit more unique to our practice because we do a lot of guardianship work. Okay, a guardianship is only necessary if you became incapacitated in the future and you did not have powers of attorney in place or other decision makers in place to be able to make medical or financial decisions for you. Now, this document doesn't appoint a guardian for you. All it says here is that if you ever needed a guardian in the future, this is who you would want the judge to name for you. Oftentimes, we see these in situations of exploitation, right? Like I said a minute ago, a lot of elder abuse and exploitation out there. And get this, between family members, right? And you know that a lot of people are, you all are shaking your heads that family members can even abuse powers of attorney, right? They can be taking advantage of mom and dad. And so that might be an example when even if you have a power of attorney, you might still need to get a guardianship in the future. And this document is used as instruction for that process. Now, you may be telling the judge in your state of incapacity, well, I want the woman who is 40 years younger than me, who's taking advantage of me, to be my guardian, right? And then you have your family members that say, oh, no. When dad did have all of his faculties, he really did want his family members to make those decisions for him. So that's the importance of the Declaration of Guardian. So that's phase one. Now we're going to transition over to the documents to make sure that your wishes are followed after you pass away. You all have heard of the will, right? Everybody's heard of a will and probably a trust. And then the one that's not listed on here that I just want to mention is also an appointment of agent for the disposition of remains. Kind of a mouthful, but we heard earlier this morning from Dignity Memorial and the importance of making your wishes known in advance with respect to your remains. So this is another document that is, again, really key with respect to this whole roadmap to the aging process, naming your agents, work with a funeral home like Dignity Memorial to carry out your wishes about whether or not you want to be cremated or where you want to be buried. So that one, and then of course your will and your trust. So we're going to talk about the will first. Everybody knows what a will is, right? The will is a document where you are dividing your assets upon your passing. You got two or several, but two main decisions in the will. Number one is who is going to serve as your executor, and two is how you want your estate to be divided upon your passing. Now with executors, again, I mentioned a minute ago, I really do recommend individual executors as opposed to co-executors, right? And that can be the same people that you listed under the durable power of attorney that you are then listing as the executors under your will. Their job, go out, collect your assets, pay off any debt, and distribute those assets to your beneficiaries upon your passing. Now, wills are very important, especially when we're dealing with blended families, okay? Because if you don't have a will, then your estate doesn't go all to the government, right? But then the state of Texas has essentially written a will for you. So they say, and if you die intestate, is what that means, then it says that these are who your legal heirs are going to be. And if you have a blended family, then there's some details and qualifications here, but roughly it goes 1/3 to your surviving spouse, and 2/3 to any children from a prior marriage. So that may not be what you want it to be. Point being is that's why you have to have your wishes known in writing. You have to have it formally signed, right? You got to have it 2 witnesses and a notary to make it fully self-proved is what we call that. The will, though, has to go through the probate process. Okay? Just because you have a will, you have a document, doesn't mean that your executor, the person named in your will, has any authority to act until a court has determined that the will is valid and that that executor is qualified to serve in that role. Okay? And we could go on into a lot more detail, but generally you should know that probate is not always necessary. It depends on how your assets are titled. We just heard some more, talking about beneficiary designations and other things like that. That's a non-probate asset. Okay, so you want to make sure, though, that your beneficiary designations line up or match your overall plan in your will, because your beneficiary designations are going to trump what is in your will. So if you have people, designated in your will but not in your beneficiaries, you should know that those people in your will may not end up taking. Okay, so you want to make sure that those two plans merge or mesh well together, and you got to think about that long term. We talked about testamentary capacity. This just is the capacity to sign a will. Is essentially that you gotta know what your stuff is, right? Know what your assets are and know who you're giving them to, and that's what we call testamentary capacity. You can sign a will one day, and you can totally forget that you signed it the next day, and you could actually still meet this testamentary capacity test within the law. So every situation is different. Okay, and we talked about it only being effective once it goes to court. Other things to think about within your will, it's not just your executor and who you want to get your stuff. There's also things that what we call contingent trusts built into wills. So if you have anything going to minors, right, or young children, then it's important to include testamentary trusts within that will, as well as incapacitated beneficiaries. Maybe your beneficiaries are not incapacitated right now, but they may be in the future. So I include a special needs trust, a contingent special needs trust in all of my wills. Okay, so that's something to think about. Even for spouses, right? If one spouse dies, leaves everything to the surviving spouse, we could trigger a special needs trust should that surviving spouse need Medicaid or VA benefits in the future, and then those assets in that special needs trust do not count when we are looking at those public benefits. So something just to keep in mind there. Now, I'm sure you have all also heard of trusts, right? Trusts, unlike a will, administers your assets both during your lifetime as well as upon your passing. Okay, you are signing a trust. It's a legal agreement, a legal document. You name a trustee to manage those assets for you. But most importantly is the second bullet here, right? Is it requires maintenance and upkeep. Because a lot of times people will come to me and they say, I have this trust. And I say, that's great. What's in it? And they say, what do you mean what's in it? It's got, 100 pages in it. It's leather bound, right? And you got it at a steak dinner. And it's beautiful, right? But you have to transfer your assets into that trust to be able to manage it, okay? And oftentimes people don't keep up with it, so it doesn't serve its purpose. One of its purposes is to avoid the probate process, okay? As well as some other issues. I just will say that when it comes to Medicaid planning, right, trusts don't necessarily merge well with that and public benefits planning. And the reason being is that your house, outside of a trust, your homestead is an exempt asset. Doesn't count for Medicaid purposes. But if it's titled in your revocable living trust, it's countable. Okay? So that's just something to keep in mind and some planning that we really want to do. Maybe we need to pull that house out of the trust and we need to do a particular type of deed that would eventually pass it back into the trust upon your death. Okay? All right, and then I know I'm coming short on time here a little bit. But lastly, just want to touch a little bit about paying for long-term care. We can summarize this slide by saying that long-term care is expensive, right? We all know that. Okay, so your options for paying for long-term care, first of all, what is not an option is Medicare. Your Medicare does not pay for long-term care. At most, it's going to get you a portion of up to 100 days in a skilled nursing setting. But after that 100 days or sooner, Medicare stops. your options then become private pay, right? And so at-home care, memory care, skilled nursing, we're talking $6,000, $9,000, $12,000 per month. Clients look at me and they say, well, I'll never need Medicaid. I'll never need public benefits, Lauren. But at these rates, this can clip through anybody's assets very rapidly. So this is why we all need to be thinking about this and making sure that our documents and our future plans and our agents have the authority to help us plan for this in the future. Surmise this to say that Medicaid is an income asset-based benefit, right? So they're going to look at your gross monthly income of a married couple or a single individual before you're going to qualify, as well as your assets, okay? And so just know for a married couple, it is a kind of a complicated equation. For a single individual, you can have no more than $2,000 in assets, but that's countable assets. We talked about your house being exempt. That's not countable. You can have one vehicle of unlimited value. And then recently, they also exempted qualified retirement accounts. If those IRAs are within that payout status and you're receiving your required minimum distributions. So that's just a little tool in our toolkit, and another reason why you may qualify for Medicaid sooner than you think, okay? So lots of other things that go into Medicaid. I do want to touch on briefly is that in Texas, you know, it's federally funded but state managed. Everybody's rules are different. In Texas, Medicaid really only pays for skilled nursing. And that leaves a gap for memory care, like if you have cognitive diagnosis, you know, Alzheimer's, other forms of dementia, you're probably going to need memory care, which is licensed as assisted living. And Medicaid does not pay for memory care for the most part. So something just to keep in mind. But there are some other, you know, kind of tools and techniques that we got to plan for. And lastly, there's also a long-term care benefit for veterans, okay? This is what we call aid in attendance. I don't know if we have any veterans in the room that have heard that phrase, but this is also an income asset-based benefit. The VA is going to look at the veteran or his or her surviving spouse, their income, and they're going to want to see what medical expenses they are incurring that might offset that income. And then they're also going to look at your assets, which is this year, it changes every year, but it's $155,000 in assets that are countable. Your homestead is exempt for VA purposes as well. Okay, so I know I raced through that last part, but I know I'm out of time. So I'm sure people have questions and that we can continue the conversation.
Quick question.
Yeah.
Does Texas have a cap that allows you to avoid probate?
No, there's no particular cap. It just depends on how those assets are titled. So it doesn't have anything to do with the amount. So for example, if you have beneficiaries listed on it, it's not going to be a probate asset. If you have joint ownership or things like that, you're also going to be able to avoid probate.
A quick example, when my dad died in Illinois, he had less than $100,000 in non-trust designated assets.
Yeah.
And so all he had to do is send a letter to the county saying he had assets, did not have assets in excess of
Correct.
$100,000.
And we do not have anything like that. We have certain types of probate proceedings that are more geared towards smaller estates. We have what's called a small estate affidavit, but that still has to go through that court process and get a judgment, a signed order.
Any other questions?
Yeah.
Does the power of attorney signed in Texas, is it valid for
Oh.
property, for real estate sales throughout the country?
So the question was, is a power of attorney signed in Texas valid essentially in other states, and in particular with regards to real property? The answer to that question is that these documents are state-based documents. So if you're trying to sell something in Illinois or somewhere else, you're likely going to need those state-based documents there. Now, the power of attorney, though, to the extent that you have bank accounts with a national bank, right, that bank is going to accept that. But the general principle is that if you are moving states or dealing with assets in other states, then you need to make sure to check with an attorney in that state, okay, because these are state-based documents. Yeah?
Did you bring some cards with you? This is so tiny, I can't hardly read it.
Oh, no. Yes, exactly. And I can send you a bigger one, too. So I've got cards in the back as well. And so in those other Catholic forms in the back with the specific language for Catholic medical power of attorney and the Catholic directive as well. Anybody else? Any other takers? I know you guys have been here all day, so it's been information overload for you.
Lauren, thank you so much.
Yeah.